The Foreign Intelligence Surveillance Court, or FISA Court, was established by Congress in 1978 to oversee the government's foreign intelligence surveillance. The reason it was established is that in the 1970s, the Church Committee had documented widespread surveillance abuses by the intelligence community within the United States. The compromise that Congress struck was to permit the government to continue to target legitimate foreign intelligence targets, but to subject that surveillance to oversight to prevent further abuses. Today, 40 years later, the FISA Court sits in a federal courthouse in Washington, D.C., where it continues to issue surveillance orders at the request of the government. It is secretive by nature because the government often presents the court with extremely sensitive details about the individuals it wants to target or the technologies it wants to rely on. As originally designed by Congress, the FISA Court was meant to hear individualized surveillance requests by the government. The FISA statute allows the government to go to the court when it believes it has probable cause to believe that a particular individual is an agent of a foreign power. And if the court agrees with the government that that individual is in fact an agent of a foreign power, then the court will approve surveillance of that person for a set duration of time. Today, the court hears about 1,000 to 2,000 of those individualized surveillance requests every year, and it approves the overwhelming majority of them. In the court's 40-year history, it has disapproved of about 40 of those requests, although the government points out that in many of the requests that it submits to the FISA Court, it engages with a back-and-forth process of adjusting the request to comply with the court's demands. The FISA Court was originally designed to oversee individualized surveillance requests, and for the first 25 years of its operation, that's exactly what it did. But in the years after 9/11, the government asked the court, and the court agreed to oversee large scales of bulk collection of Americans' information. In 2006, for example, the government asked the FISA Court to approve the bulk collection of Americans' call records. Under that program, the NSA would, on an ongoing daily basis, collect the call records of Americans from the major telecommunications providers in the country. In 2015, Congress legislated to end the domestic mass surveillance programs that started after 9/11. But there's one critical exception, and that's Section 702 of FISA. Section 702 forbids the government from targeting known Americans or others inside the United States. Instead, the statute requires that the government target foreigners abroad, and it must be targeting those individuals to collect what the statute calls foreign intelligence information. That phrase is defined very broadly to include not just information about terrorists, but information about the foreign affairs of the United States. The primary complaint of privacy advocates about Section 702 is that in collecting that information, the government will predictably collect the information of many Americans. The primary protection that Section 702 provides to Americans is that it requires the government to comply with what are called minimization procedures. Those procedures are supposed to be designed to protect Americans' privacy when they're swept up in the surveillance. Once an American's communications are swept up under Section 702, they go into government databases, and there those communications can be searched for by the FBI, for example, in the course of criminal investigations. And so long as the government has an argument that accessing Americans' communications is necessary to understanding so-called foreign intelligence, the government can retain those communications and use them for many purposes. Critics of the court say that the mission of the court has crept over time to authorize increasingly broad surveillance that increasingly sweeps in the communications of Americans, all without any warrant. They also point out that much of the development of FISA court law happens behind closed doors, making effective oversight of the court difficult and making it difficult to assess whether the legal interpretations that the court is developing in secret are consistent with our laws. Proponents of the FISA Court say that the court gives the government a secure forum in which to present sensitive information justifying important surveillance requests. They also say that the authorities that the FISA Court oversees, like Section 702, give the government important surveillance authority in the context of its fight against international terrorism and other international threats.